So now you got the second team. What happened to the lights? Okay. I think we can soldier on. Good afternoon, everyone. Welcome to the Court of Appeals. Judge Frierson's has already done the introduction, so there's no need for me to deal with that. I just want to make everyone aware, as you make your argument, that we're live streaming this, and if you just be careful what you're saying, I guess is the best thing to say. So, having said that, if Ms. Angie, you may call the next case, please.
Kisha Dean Trezevant versus Stanley H. Trezevant III.
Good afternoon, Your Honors. Donald Caparella, Nashville Bar. Represent Trip Trezevant in this divorce case. I'd like to reserve 3 minutes for rebuttal.
3 minutes. You may proceed, sir.
Your Honor, the really only issue in this case is the division of marital property. And the trial court's division of marital property is so inequitable because the trial court made 8 substantial errors in evaluating the statutory criteria. And the errors are of law and math, as well as factual findings. The first of the 8 errors is the largest one, and it relates to debt related to one set of properties. The parties owned marital property in the Cayman Islands, and the parties stipulated that the Cayman properties totaled together $5.9 million. They stipulated this in the first trial, they stipulated this in the second trial, and then when it was sent to a special master, they stipulated it at the special master hearing, and the special master incorporated all those findings about the property into his ruling. So when they went to trial, the parties then swore in their asset and liability statements that there was no debt on the Cayman Island properties. So as they went into the trial, proof went in, everybody was clear there was no debt on the Cayman Island properties. Then the wife's counsel, when they were cross-examining the husband, put before him an affidavit from a Cayman Island lawyer that suggested that there was actually debt on the Cayman Island properties, $7.25 million in total. The husband denied that, disagreed with that, and throughout his entire testimony said he was not aware there was any debt on that property. But then they introduced that affidavit as an exhibit, essentially arguing that their stipulations, their sworn testimony of the wife was not true, and therefore there was debt on the property. Prior to the final ruling, the parties submitted post-trial briefs in lieu of oral argument. And the husband took a different position because of the wife's challenge to the debt issue on the stipulation. He said, I want all the property given to me. I'll take all the debt, including this debt that you claim exists on the Cayman Island properties. And the wife took the opposite position from what she had taken at trial when her counsel put the debt into evidence and said, no, there's no debt. We must stick to the stipulations. And before I'll go on, I'll just say that's the secret key to resolving this appeal, is make the parties stick to the stipulations, particularly since the stipulations got wrapped into a special master ruling, and Rule 53.04 of the Rules of Civil Procedure says that when the special master rules, and the parties did as they did in this case, they stipulated not only to the values, they also stipulated to the special master's hearing, their rulings, only issues of law can come up. So when the trial court ruled that the trial court was not going to abide by the stipulation, trial court was bound by the stipulation. But still, what she did was she awarded the Cayman Island properties to the wife with the debt.
Counsel, excuse me for interrupting. Could you address the effect or impact, if any, of equitable estoppel with regard to this issue?
Absolutely, yes. So it arises as I finish that story a little bit. I have to give a little context. After the court ruled, saying there was $7.25 million of debt and we're giving the property to the wife, the husband filed a motion to alter or amend, saying he had newly discovered evidence that there was no debt. And then the wife, in response, said, no, we're happy with the ruling. The stipulation should go away, and in fact, there is debt on the property. So you have both parties taking inconsistent positions as to the debt, as to whether the debt exists. And equitable estoppel is a creature of equity. Equitable estoppel, if you are changing your positions as to debt, which is the wife did, and the husband's changing his positions as to whether the debt exists or whether the stipulation exists, then you don't have sort of primacy over the person. They're both making tactical choices to try and get this property, the Cayman property, either without debt or with debt, depending on their positions. So, not to mention the fact that they asked the trial court to award equitable estoppel against the husband, and the trial court didn't do it. And yet, on appeal, they didn't raise that issue as a statement of issues in their brief, because when you're the appellee and you're trying to get relief from the trial court's judgment, you have to state it as an issue as if you're an appellant. You can't just sort of sit on that. And so they've waived it on appeal by not raising it as one of the issues on appeal. It's also an affirmative defense that we've never had a hearing on it as far as the merits of it, so you really can't get to it. So it's waived in multiple ways, but more importantly, you can't get equity if you are doing the very same thing that you say the other person's doing that prejudiced you. And wife's first position was there was no debt by stipulation and by swearing. And then she argued, had her lawyer introduce evidence that there was debt. And then when she got the property, she said there wasn't debt. So 4 times she changed her position. Husband changed his position 4 times. She got the property and she got the debt. And think about that. Obviously, you would not want a $5.9 million piece of property if it's got $7.25 million in debt, if you really believed it, that really had debt on it.
The original stipulation was no debt on the Cayman Island properties. Is that correct?
The original stipulation in the first trial, the original stipulation during the special master hearing, and then they stipulated the special master ruling, and then she swore under oath, as well as a stipulation in her asset and liability statement, there was no debt on the property. And there's no dispute that judicial estoppel doesn't apply here, because neither party had conflicting oaths. They both swore there was no debt. Now, no one can change a stipulation, Your Honor, except for a trial judge on a finding of fraud. But Mr. Trezevant isn't defrauding anybody about whether there's debt or not. He is simply saying, you proved there was debt, so I'm going to take advantage of the proof you just put in, and took an inconsistent positions, which lawyers do all the time. So there is no equitable estoppel, and my brief goes in more detail about it, but there's no equitable estoppel. But more importantly, if they asked the trial court to award equitable estoppel relief on this issue in the post-trial motions, and the court didn't do it, for them to raise that as an issue on appeal, they had to put it in their statement of issues, and they did not. So when you have a $7.25 million debt poured into a $13 million estate, when the debt doesn't exist, you have a major mathematical error that skewed it to such an extent that the wife ended up with a piece of property, $5.9 million, with $7.25 million of debt that doesn't exist, which is a tremendous windfall to her. And there are numerous cases from this court that I've cited, as well as other cases, that when you have an error of that magnitude in an estate, even a large estate, $7.25 million is a lot of money, you must remand and enforce the stipulation. If Mr. Trezevant had been successful in getting getting out of the stipulation, the wife would have had a good argument on appeal, because you can't get out of the stipulation. Even the trial court couldn't get out of the stipulation unless she found that somehow it had been procured by fraud, and she didn't, or some Rule 60 motion had been done. But instead, the trial court just said, I'm going to ignore the stipulation. And trial courts can't ignore stipulations, and if they could easily, then they wouldn't matter. So that's the first error. Of course, the second error is a $2 million math error, because when the trial court actually put in this very long Excel spreadsheet and did the math, the $7.25 million debt that didn't exist was only counted as $5.25 million. It's a $2 million error. Now you say, well, opponents argue, well, that's to his advantage. Whether it's $7.25 million or $5.25 million, it's a very large error, and it totally skews this. And still, the wife is getting a piece of marital property that has no debt on it, and yet it's been counted as if it does. So that's another error. The third error has to do with more math errors. As Your Honor knows, under the statute, the court has to consider the separate property of both sides. The wife was found to have $1.5 million of separate property, and yet, when you do the math, and it's in my brief, it's very clearly the court had 12 items to add up, but only added up 2 of them, and ended up with $1.5 million when the math is very clearly $2.6 million, so $1.1 million error. And my opponents don't argue with the error. They just say it's a Scrivener error, it doesn't matter that much. But again, there's multiple case laws that says when you have separate property that has been undervalued or misvalued to this extent, the trial court needs to get the math right on remand and not just simply skip over it. Now, on the husband's separate property, there were 3 pieces of marital property that the husband argued had marital debt on it. The trial court found, either on its own or by stipulation, what the value of the property was, but said this property, East Broadway, 2100 East Broadway, Shops of Milan and Goodman Malone, the debt, Mr. Trezevant, that you're arguing is marital debt, it's not marital debt. It's separate debt. But then the court didn't put it into his separate property part, just wiped it off the marital column and left it unattended at all. So when the court found that he had $1.9 million in separate property, he actually had negative 1.3. The $3.3 million in marital debt that really wasn't marital debt, because the court said it wasn't, didn't get put onto his separate side. So again, the court was evaluating a key factor, how much separate property they have, and was millions of dollars off. Last, well, I have 8 errors. I'll let my brief speak for the ones I can't get to in this oral argument. The husband had a piece of property, Trezevant Enterprises, that was the spoke on the wheel of all his properties. And all the money flowed in and flowed out. It was a pass-through entity. And the first trial court found it was a pass-through entity. The second trial court found it was a pass-through entity. Both first trial court said it had 0 value. The second trial court said it's got no assets, but I'm not going to do an asset value analysis. I'm going to do an earnings value, and found that actually it's got a $720,000 value, and we think it has a 0 value. And more importantly, and I'll just close with this, the court used that same $720,000 a year derived from loans that he gave himself, and used it twice, used it again in evaluating his income when it found that he had $1.4 million in income, when the special master found only that his income was $582,000, or I think the phrase was at least $582,000. So all these 8 errors, beginning with the Cayman error, are enough to make this so marred in terms of his errors that this court should reverse and remand with these errors corrected for the trial court to more equitably divide this marital estate. Thank you.
Thank you.
Good afternoon. If the court please, I'm Mitch Moskovitz. It's nice to see you again. And I, along with Adam Cohen in our office, represent the appellee, Kisha Trezevant. I'm going to start a little bit unusual, which the court may consider who's arguing. Well, it's not particularly unusual for you, Mr. Moskovitz. And I say that because often as advocates for litigants, particularly in divorces, these cases become so enmeshed with emotion. And when I sat a day or two ago and reread the briefs, given the tortured history of the Trezevant ordeal, and I remind each of you, this case emanated in August of 2013. We are now 10 years post the filing of a divorce complaint in Shelby County. This is our second appeal before this court. There have been numerous attempts to go beyond this court. There have been other attempts to get to this court, and there is an analogous appeal by the appellant, Mr. Trezevant, pending before this court on a finding of some roughly 4 counts of criminal contempt and 40 days that's been suspended pending what the Court of Appeals may do. I say that because a brief review of the history is incredibly important, and in due course in time, Judge Frierson, I look forward to responding to the answer to your question, and in my 15 minutes, I suspect that I'll have more than ample time to do so. But I think the basis of your question, which deals with taking inconsistent positions insofar as estoppel, and I'll cite our Supreme Court case that we've cited in our briefing more thoroughly, but I think it's critically important because what we're dealing with here is exactly, quite frankly, what the 2 trial judges who've heard this matter, both Judge Fields in late 2016, some 7 years ago, that gave rise to an 82-page opinion in March of 17, and again what Judge Wagner on remand decided in 2020 in some 40 pages approximately of her findings of fact and conclusions of law. I remind each of you, and it's in this record, as voluminous as it is, that Mr. Trezevant made a point when this whole process started 10 years ago. And what he said is, Ms. Trezevant, and he didn't refer to her as Mrs. Trezevant, but he said, this is going to be a decision you will regret. Well, you can cast aside emotional statements that litigants, particularly in divorce cases, may make, because we often find them not what one might suggest at their best. But casting aside what Mr. Trezevant has suggested some many years ago, look and listen what's in this record to what Judge Fields and what Judge Wagner, and candidly, what this panel has said. And I emphasize, without being too terribly repetitive or redundant, but I think it's critically important. This court, in its first opinion, 568 Southwest 3rd, at page 624, noted that Mr. Trezevant has been both deceitful and dishonest. Judge Wagner, on remand, not terribly long ago, said, and I quote, and I'll attempt not to regurgitate by quote facts or findings that are determined or set forth in our briefing, but I think it's critical because the background in this case is nothing other, quite frankly, than tragically a litigant making litigation a game. And you've got 2 very reputable, skilled trial judges in this panel and other panels that have dealt with this for years, and I submit to the court most respectfully, it's got to stop. I thought of a better term than madness, or attempted to come up with a better term than madness, but frankly, I couldn't come up with anything any better. And this madness must stop. It's been 10 years. As Judge Wagner opined, Mr. Trezevant, and I quote, will say what he needs to in order to get what he wants in the moment. This is regardless of whether it's supported by truth or even previous testimony. Throughout these proceedings, he has routinely, in response to your question, contradicted prior testimony or assertions. Judge Wagner, again, on remand, found Mr. Trezevant not to be credible. Judge Wagner, again, found that Mr. Trezevant has hidden assets, loans, failed to disclose assets and loans, and the court cited, numerous examples that we've reflected in our briefing. Judge Wagner noted, and I think it's critical, that Mr. Trezevant would take what action, if any, necessary, consistent with that remark he made some 10 years ago, that this will be a decision that you'll regret, to defeat a trial court's division of his wife's entitlement of what portion of the marital estate. Let me briefly attempt to address the first issue raised by Mr. Trezevant. And that is quite interesting. And I'm going to attempt to hearken back to my remarks insofar as what both trial judges and what Mr. Trezevant himself said at the onset or commencement of this litigation. But I want to emphasize that it should, and I think it does matter what a trial judge determines, and it does. The division of marital assets, as this court is well aware, is afforded great weight. It's afforded a presumption of correctness. And when a trial court's factual findings rest on its assessment of witness credibility, this court, most respectfully, will reevaluate those findings only when clear and convincing evidence to the contrary exists. Again, he'll say whatever he needs to get what he wants at the moment. Trial Exhibit 95, and again, my colleague and friend, Mr. Caparella, and I felt like we were here just yesterday. He and I have been before this court and other courts and our courts of appeals on many occasions, and Mr. Trezevant hires the best. But Mr. Caparella can't make fact and law. He can argue. And fortunately, there's a record with two, in at least this instance, again, a very skilled trial judge. Trial Exhibit 95 was introduced with no objection by agreement. That trial exhibit reflected, and in this record, it reflects that there is $7.25 million of debt secured by certain Cayman Island properties. In response to your question, Judge Frierson, yes, there was a stipulation, and yes, it was Mr. Trezevant who suggested that that $7.25 million debt exists. And yes, it was Mr. Trezevant, despite the stipulation, who, when Mrs. Trezevant suggested in the post-trial briefing that the court ought not give credence to the $7.25 million in debt, and I quote, that as counsel said, that's utterly nonsensical. A timeline, I think, is critically important. Trial Exhibit 95 came into evidence by agreement with no objection on October the 1st, 2020. Couple comes back to court for the next day before Judge Wagner on October the 6th. The briefing was done on November the 20th. Mr. Trezevant and or Mrs. Trezevant, and I think it's largely immaterial, but in my recollection it was Mr. Trezevant who wanted to dispense of closing arguments and wanted to submit a post-trial brief, took the position that he wanted the Cayman properties and that the $7.25 million in debt secured by those properties existed. It's the very definition, Judge Frierson, of estoppel. And we've cited that and cited the case, Tennessee Supreme Court, 2009, Cracker Barrel versus Epperson, 284 Southwest 3rd, 303. And I emphasize.
Counsel, excuse me for interrupting.
Yes, of
Could
course.
you address the appellant's position that the matter of equitable estoppel has been waived on appeal?
Whether it's equitable estoppel, which I disagree, and let me address that. I will address. It has not been waived. We, on behalf of Mrs. Trezevant, the appellee, are taking the position that the trial court got it right. We asserted in the defense of Mr. Trezevant's post-trial pleadings that after, and I emphasize this as well, and it's in our briefing, after the court awarded the properties, the Cayman properties, with the debt to Mrs. Trezevant, and against our objection, found that Mr. Trezevant was correct, And I remind the court that Mr. Trezevant was always in control of these Cayman properties. It was only in February of 2021, months after this came up in October, and months after his November 20, 2020 briefing, did Mr. Trezevant assert, well, now that you've awarded the properties to Mrs. Trezevant with the debt that I asked the court to include despite the stipulation, it doesn't exist. I remind the court that we raised that in our briefing, equitable estoppel, and the court disagreed. And we've said the trial judge in her ruling got it right. We've not appealed that, but that doesn't waive our position in response to Mr. Trezevant's argument that equitable estoppel applies. And we believe that it does apply, that he is estopped, that it fits to the precise language of what the Supreme Court has said, and we raised it in the trial court. We lost. There was no need for us to raise it before this court insofar as an issue on appeal because we are not appealing the property division. The only issue that we have raised is the award of attorney's fees to stop, as I've suggested, this madness. And so I hope, Your Honor, that appropriately responds to your question, but I don't believe in any way we've waived raising the issue when it was raised by us, and we're not appealing the court's ultimate division of the marital estate. In the few minutes that I have, let me attempt to address this issue about $2 million. It's interesting. Mr. Trezevant is a master at creating issues. I would define him as an architect of his own deceit, and he often loses perspective of what he's actually arguing, not with his capable lawyers, but he himself. Just by way of example, as to the estoppel argument that he says, as to the stipulation argument that he says we should be bound by the stipulation despite the fact that my briefing says I shouldn't be bound and I want the Cayman properties with $7.25 million in debt, and then months later after it's awarded to his wife with the debt, he says, oh, by the way, you shouldn't have included the debt. Well, just in that, in the 8 issues that he attempts to raise, hoping some will prove meaningful before this panel, he says as to the shops of Milan and the other, there are 2 or 3 properties, that he says, oh, by the way, as to those, I don't want you to follow the stipulation again. So it's an ever-evolving argument, all of which Judge Frierson is briefed thoroughly in what we've provided to the court. But let me, again, in the few minutes I have left, this $2 million argument that he raises, if I throw enough, something may be caught. There are other terms that are used. There are other analogies that are suggested. But what strikes me is despite the time and the attention and the expense associated with raising these plethora of arguments, what he doesn't reflect is the $2 million suggested mistake benefits him by some 8%. And what I mean by that, and we briefed, is the trial judge awarded, Judge Wagner, Mrs. Trezevant, some 58% of the marital estate. If Mr. Trezevant is correct that there's a $2 million error, and we're not appealing the property division, the only thing we've asked on appeal is that because of where we are and where we find ourselves, a basic review of this record would indicate if there is a case to award a litigant attorney's fees, both at the trial level and at the appellant level, this is it. He should not be afforded the opportunity to make a mockery of our jurisprudence system. And I know those are harsh terms, and I know I'm a divorce lawyer, and I know we're often said, well, you guys are so emotional. But this record, I dare this court respectfully to find another divorce case that has the history of this case and is 10 years plus in litigation. And I dare suggest where you find enough arguments, including one that benefits a litigant by 8% of the marital estate that they raise in front of the Court of Appeals. Contradictory? Gamesmanship? Inconsistent? It's the very definition of Mr. Trezevant, and it must stop. I thank each of you on behalf of our client, and I'm asking most respectfully to affirm the trial court in all respects with one exception, to please give consideration to the award of attorney's fees. They have spent hundreds, if not more, thousands of dollars, and it needs to stop. I thank you all for your time.
Your Honors, I want to address this equitable estoppel argument again, based on comments of my opponent. There are two reasons that I can think of right now why equitable estoppel does not apply. Equitable estoppel is an affirmative defense. It's an attempt by a defendant to get relief as an affirmative defense, which is a claim of a kind. And they asked the trial court to say, look, Mr. Trezevant has changed his positions multiple times about whether this debt exists. And, Your Honor, Judge Wagner, give us that relief. And the trial court said, I'm not. Just denied all the motions to amend afterwards. When an appellee loses a claim or loses an affirmative defense, whether it's statute of limitations or in this case, equitable estoppel, they have to appeal that issue to get relief from the trial judgment, otherwise they waived it under clear law. And there's nothing in their statement of issues that makes that argument say they've waived it. But on the merits of equitable estoppel varies from judicial estoppel in this way. Judicial estoppel is about swearing something to the court and then swearing the opposite. The light was green, says the person. And then later on they say the light was red. And that offends the sanctity of the court because it offends the sanctity of an oath. Here, the only oaths were, by both parties, as well as stipulations, there is no debt on it. And then when counsel, it was not this counsel, it was another trial counsel, introduced Exhibit 95 and said, said Ms. Trezevant's counsel, there is debt on this property. There's $7.25 million of debt. I must correct opposing counsel. Mr. Trezevant didn't say there's debt on the property at that point. He defended himself in cross-examination. Matter of fact, the trial court expressly said, throughout the trial, he said, there is no debt on the property. And I know what these documents say, but I'm not aware of any debt. Then he did what litigants often do. He tries to seize an opportunity to take an inconsistent position that he thought would benefit him. Just like in the Cracker Barrel case, the case they cite, where somebody said, they took the position that this particular phrase about awarding attorney's fees in a contract, we want our attorney's fees. And then when the other side wanted to get attorney's fees under that same language, they said, well, they don't get attorney's fees. We do, but they don't under the exact same language. And the Supreme Court of Tennessee said, that is not equitable estoppel. That is inconsistent pleading. That's all Mr. Trezevant did. And then when the ruling went the way it went, he changed his position and said there is no debt as a matter of fact, but the court denied that as well. We're not even appealing that because it couldn't meet the standard of newly discovered evidence. But here, as I go through in my reply brief very carefully, the sequence, the wife was the first one to challenge whether there was debt, and for her to try and get equity when she's doing the very same thing he is means that they don't get the equitable estoppel argument. So request for attorney's fees and reverse this and remand it for a new redistribution of the division of marital property according to the errors that you find the trial court made. Thank you.
Thank you. Thank you, counsel. We'll take this matter under advisement and attempt to get you an opinion at the earliest possible time.
Thank you.
Thank you. You may be excused.
Thank you.